Hello, everyone. Welcome to US Move and Money. Today, we're talking about a development that has created serious concern across immigrant communities, workplaces, and families all over the United States. Green card holder deportations have now been confirmed under new U.S. immigration rules rolling out in 2026. And this is not just speculation anymore. In a recent development, reports suggest that lawful permanent residents are facing increased enforcement actions that were rarely applied this aggressively in the past. What's at stake here is not only legal status, but also family unity, employment stability, and long-term security for millions of people. In this video, we'll break down what has changed, who is affected, why this is happening now, and what you can do to protect yourself. If you're interested in this topic, please stay tuned until the end of the video. If you find this information helpful, hit the bell button, subscribe, and like so you never miss an update from US Move and Money. Now let's get into the details. In a recent development, the landscape of green card enforcement has shifted in a way that many immigration experts say marks one of the most significant changes since the early 2000s. According to sources familiar with internal policy guidance, the Department of Homeland Security has confirmed expanded deportation priorities that now explicitly include certain categories of lawful permanent residents. This includes individuals who have held a green card for years and, in some cases, decades. Previously, deportation efforts were largely focused on undocumented immigrants or green card holders convicted of very serious crimes. However, what makes this case different is the broader interpretation of deportable offenses and the increased coordination between United States citizenship and immigration services, immigration and customs enforcement, and customs and border protection. Officials argue that these changes are designed to strengthen public safety and uphold the integrity of the immigration system. In a recent statement, a senior Department of Homeland Security official declared that lawful permanent resident status does not mean immunity from immigration law enforcement. The administration claims that the law has always allowed for deportation of green card holders under certain circumstances, but enforcement was inconsistent. What this means now is a more systematic review of green card holders who may fall under deportability grounds listed in the Immigration and Nationality Act. To put this in perspective, reports suggest that internal audits conducted in late 2025 identified tens of thousands of cases where green card holders had unresolved legal issues that could trigger removal proceedings. Before these new rules, many green card holders believed that once they passed the initial adjustment of status or consular processing phase, their risk of deportation was minimal unless they committed a very serious crime. While that belief was not entirely accurate under the law, enforcement practices reinforced that perception. In 2026, that reality is changing. The new guidance emphasizes mandatory referrals from USCIS to Immigration and Customs Enforcement when certain red flags appear during routine interactions, such as green card renewals using Form I-90, applications for naturalization using Form N-400, or even when filing a family petition like Form I-130 for a spouse or child. So, who exactly is affected by these confirmed green card holder deportations? According to sources, several categories are now under closer review. First, green card holders with criminal convictions that were previously considered minor or non-deportable are now being reassessed. This includes certain fraud-related offenses, domestic disputes classified as crimes of moral turpitude, and drug-related offenses that do not involve trafficking but still appear on criminal records. Second, green card holders who spent extended periods outside the United States are also facing increased scrutiny. If Customs and Border Protection determines that a person abandoned their permanent resident status, removal proceedings can be initiated even at the airport. Additionally, individuals who obtained their green card through marriage-based petitions such as CR1, IR1, or adjustment of status using Form I-485 are being reviewed for past misrepresentations. Immigration experts note that discrepancies discovered years later, even unintentional ones, can now trigger notices to appear in immigration court. For example, if an applicant failed to disclose prior employment, a previous visa overstay, or an old address during the green card process, officials may argue that the green card was obtained through misrepresentation. What this translates to is that historical paperwork matters more than ever. There is also growing concern for conditional green card holders and those who recently removed conditions using Form I-751. Advocacy groups warn that any unresolved issues during the conditional period may now resurface. Even employment-based green card holders under EB1, EB2, and EB3 categories are not entirely immune. Reports suggest that individuals whose employment circumstances changed shortly after approval may be questioned about the original intent of their petition. While this does not automatically lead to deportation, it can open the door to enforcement review. Beyond individual cases, the broader implications of these rules are significant. Processing times are expected to increase as USCIS officers conduct deeper background checks and refer more cases to immigration and customs enforcement. Immigration experts note that adjustment of status applications, which already take 14 to 16 months on average, could face additional delays due to expanded security reviews. In addition to these changes, requests for evidence, commonly known as RFEs, are becoming more detailed and frequent. Applicants are being asked to submit court records, travel histories, and financial documentation going back many years. Legal analysts suggest that this shift is part of a larger policy trend emphasizing enforcement over discretion. While there have been some modifications to enforcement priorities under different administrations, the 2026 framework appears to institutionalize a stricter approach. Critics argue that this creates fear among lawful permanent residents who have built lives in the United States. Advocacy groups warn that families could be separated and employers could lose skilled workers due to deportations that could have been avoided through discretionary relief in the past. Despite these challenges, it is important to understand the practical impact for current green card holders. If you are a lawful permanent resident, this situation might feel overwhelming, but knowledge is your first line of defense. In practical terms, you should be cautious when interacting with immigration authorities and ensure that all applications are accurate and complete. Consulting an experienced immigration attorney before filing for naturalization, renewing your green card, or traveling internationally is now more important than ever. Immigration experts note that applying for citizenship can sometimes trigger a review of your entire immigration history. So, preparation is key. There are also potential silver linings. Some legal experts believe that the increased enforcement clarity could encourage green card holders to resolve outstanding legal issues proactively. This may include expunging eligible criminal records, correcting past immigration filings through legal channels, or applying for waivers when available. The real question is how consistently these rules will be applied and whether courts will push back against overly broad interpretations of deportability. Looking ahead, it remains to be seen how Congress and the judiciary will respond. There are already discussions about potential legal challenges, arguing that the new enforcement approach undermines due process protections for lawful permanent residents. Political responses may also shape how aggressively these rules are implemented. Based on current political discourse, immigration will remain a central issue throughout 2026, and policy adjustments are always possible. As a green card holder or applicant, staying informed through reliable sources like US Move and Money is essential. Monitor official announcements from United States Citizenship and Immigration Services, and be cautious of misinformation circulating online. Remember that not every green card holder is at risk, but understanding whether you fall into a reviewed category can help you make informed decisions. To summarize, green card holder deportations have now been confirmed under new U.S. immigration rules in 2026, marking a significant shift in enforcement. While the administration argues this is about public safety and legal consistency, critics raise concerns about fairness and family impact. The practical path forward involves preparation, legal guidance, and staying informed as policies continue to evolve. The future remains uncertain, but awareness empowers you to respond effectively. That's all we have for this bulletin. US Move and Money provides all necessary visa information and procedures for your US immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas, such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, please subscribe for more US Move and Money.